It's a painful story and she has pulled through it. But there are many more like Toyosi around us. Why is it usually difficult to prove sexual-related cases, especially when committed many years after? A criminal law expert talks about the science of the evidence.
Collating and presenting before the courts quality evidence. All too often, the cases involving sexual violence or any form of sexual offense takes place where there are fewer witnesses, and so it tends to be the victim and the assailant, and so it's with very few witnesses, so it's not really a case
or
no witness at all. And then you also find that because of the attitudes, the social attitudes to sexual victimization, the victim would usually not report to a person who can take down quality evidence. It's not unusual that the victim has destroyed the evidence, and then when the case is in fact reported, the capacity of the police to gather evidence in such a way that they look for the right thing that would conclude and link the offender with the offending. The willingness, I talked about the capacity, which means that the skills, the access to technological support, or what other support that helps to produce high quality evidence are some. And then I just spoke about the will to treat sexual offenses as serious offenses. Then the capacity to prosecute the case, because you can have evidence, but if the evidence is not well presented before the court, following the rules relating to evidence, then you would have challenges satisfying the court conclusively.
Tell us your thoughts about the National Sexual Offenders Register that was recently opened. It talked about those convicted as far back as 2015 being on that register. Do you think it would deter sexual offenders, sexual abuse?
Yes and no. There are very many things that go into the criminal justice system and the criminal law working deterrence. It's not just conviction, knowing that people get convicted and knowing that somebody has been convicted. Before you get to conviction, you must build confidence, the people's confidence in the fact that cases will be cleared up. If the odds of going to trial is very low, offenders will not be deterred. If the odds of apprehension is very low, offenders will not be deterred, because the likelihood that they will be caught out is low. And they will not be caught out if victims do not speak. They will not be caught if the police does not do its work, following up on reports or complaints made to it. They will not be caught if the police cannot, I said do not do their work, in which case I speak to when they willfully do not do the work. When they cannot do the work because the skills and the technology or whatever it is that is required to investigate cases are not available to support them even when they have the will, then offenders will continue to walk free. And so when an offender is faced with shall I not, knowing that it's not just in sexual offending, it's generally, you're not going to make a U-turn where you know you're going to be apprehended. You're not going to exceed the speed limit where you know the odds of apprehension are high. But you're going to do that, which is what we get in Nigeria, because you know the odds of apprehension is low. Then beyond apprehension, there's the issue of what's the quality of prosecution that ensures that the case has a good chance when it gets to court. So you have corruption, you have poor quality prosecution, you have so many things that reduce the chances of getting to conviction.
One last question, and that takes us back to the sexual-related cases, which is the law on rape, if it's sufficient to handle and punish offenders. For example, if boys are raped.
The penalty has always been life imprisonment. And of course, if we sentence everybody to life, rape is rape. And rape is a very serious offense. But I have seen cases of rape, and I have seen that some cases, I don't want to say that they're worse. I don't want to make light. I really do not want to make light. But the facts in some cases make you think that, you know what, this is worse than anything that you can ever speak to. And I say that with every sense of, caution. I do not make light. I do not make light. But I think that if we can get sentencing right, if we can sentence someone to 10 years, that is not light. If we can sentence someone to 15 years, that is not light. If we can sentence that, we want to have that range that we can use for. We can use for somebody who kept someone as a sex slave and raped her for two years. What you want to do is make your justice system work. You want to make sure every rape offender gets to justice, gets to be convicted, gets to be sentenced in such a way that you send the signal that this is unacceptable.
Welcome back. It's time for a recap of some of the top trending stories from the courtrooms.
24-year-old South African policeman Austin Luciano Reynolds, who killed a Nigerian, Ebuka Okoli, in January 2018, was sentenced to an effective 30 years in jail. Constable Reynolds, who was convicted on 3 counts of robbery and 1 of murder last Friday, got 15 years on each count of robbery, which will mostly run concurrently, and 25 years for count 3, which is murder. Speaking with Channels Television, the spokesperson for South Africa's National Prosecuting Authority, Natasha Ramkissoon-Kara, explained how the effective sentence rounded up to 30 years. Also in South Africa, convicted leader of the movement for the emancipation of the Niger Delta MEND, Henry Oka, appeared before a court in Pretoria to challenge his prosecution and conviction under South Africa's anti-terror laws instead of under international humanitarian law under the International Criminal Court Act. Mr. Oka waded through a lot of legal documentation, prepared himself, as he attempts to secure his freedom based on a technicality.
So that is a habeas corpus petition and has nothing to do with the merits of the case.
And back home, a senator and former governor of Abia State, Orji Kalu, has been sentenced to 12 years in prison. The Federal High Court in Lagos found Mr. Orji Kalu and 2 others guilty of 7.65 billion naira money laundering, while Mr. Kalu's co-defendants, Slok Nigeria Limited, and Mr. Ude Udeogu, who was the Director of Finance and Accounts at the Abia State Government House during Kalu's tenure as governor, got multiple sentences between 10 years and 3 years. The judge also ordered that Slok Company be wound up and its assets forfeited to the federal government.
And that's our program this week. Thank you for watching. Be sure to catch the repeat on air or watch via our YouTube channel. I'm Millicent Walker. Bye for now.